all persons with any business before this honourable court now draw nigh. Give your attendance and you will be heard. God save the King.
I begin by acknowledging the traditional custodians of the country on which we meet, the Gadigal of the Eora Nation. I acknowledge their many thousands of years of care and custody of this land and its surrounding waters. I pay my respects to elders past and present, as well as to all First Nations people here today. We gather today at this ceremonial sitting of the District Court of New South Wales to mark the retirement of a highly respected and valued judge of this court, His Honour Judge Andrew Haesler. I particularly welcome a number of past and present members of the judiciary of various courts, including from the High Court of Australia, the Honourable Justice Beach Jones, and the President of the Court of Appeal, the Honourable Julie Ward. I also welcome members of the legal profession, friends of Judge Haesler, his past and present associates, and extend a particularly warm welcome to his partner Katrina, son Max, brother Jeff, sister Rosalind, who is online, and his 94-year-old father Bill Haesler, with an impressive OAM for services to jazz. Judge Haesler SC was appointed to this court on 20 September 2010. What a tremendous coup it was for this court to appoint someone with the experience that Judge Haesler brought to the court. As a University of New South Wales law student volunteer, he helped set up the Redfern Legal Centre in 1977, which offered free advice to low-income members of our community. After completing his degree, he was a solicitor with Redfern Legal Centre before spending a year in Central Australia with the Aboriginal Legal Service based in Alice Springs. It wasn't long before he was known for his strong advocacy skills and intellectual rigour. In 1996, he was appointed a public defender, and in 2004 as senior counsel. In 1999, Judge Haesler was appointed Director of the Criminal Law Review Division of the Department of Justice and Attorney General, where he provided advice to government on a broad range of areas, including sentencing and court diversionary programs. In later years, he was the Director of the Redfern Legal Centre, during which time he published numerous articles and contributed to many legal texts, including the Lawyer's Practice Manual, the New South Wales Legal Resources Book, and the Law Handbook. His Honour has been a regular guest lecturer at the University of Wollongong, the University of New South Wales, and the University of Sydney. In addition to these extracurricular contributions to the administration of justice in this state, Judge Haesler has made an immense contribution to this court. He has a capacity to get through extraordinary amounts of work. He is open-minded yet decisive, efficient yet well-reasoned, and legally sound. On a more personal note, Judge Haesler is known as a go-to person for advice and guidance. His door is always open and his phone always switched on. It has been remarked to me that some of his colleagues are worried as to how they will manage without his wisdom and experience. Within 10 minutes of this ceremony being announced, the bench was full, a testament to the high regard in which he is held. Judge Haesler, you will be dearly missed by all of us. I'm very pleased you've accepted a commission as an acting judge, but I hope you can enjoy more fishing time going forward, which I know you enjoy. Finally, from your speech on the occasion of your swearing in, quote, I want to acknowledge the force and the magic of the second part of the affirmation I have taken. To do all right to all manner of people after the laws and usages of the state of New South Wales, without fear or favour, affection or ill will. There are no empty words here. It is a profound oath and one I intend to live by. Judge Haesler, you have lived by this affirmation for the last 15 years. On behalf of all of the judges of the court and the people of New South Wales, thank you for your service and dedication, and I wish you the very best in your retirement. I now call on the Junior Vice President of the New South Wales Bar Association, Miss Vanessa Whitaker, to speak on behalf of the bar.
May it please the court. That was a shock. May it please the court, I respectfully adopt Her Honour the Chief Judge's acknowledgement of country. It is my privilege to speak this morning for the bar on the occasion of Your Honour's retirement from Judicial Office. Specifically, it is my pleasure to recognise and celebrate Your Honour's contribution to the administration of justice. Your Honours has been a contribution of some 45 years, built upon Your Honour's renowned skill, learning, work ethic, and personal character. Your Honour was sworn in as a judge of this court some 15 years ago on the 20th of September 2010. But Your Honour's engagement with justice began much earlier. In happy days, when Neil Young, the musician, dominated the Billboard 200, and Your Honour was a student at Fort Street High School, according to a publication that was new to me until recently, the Illawarra Region, reporting under the headline, "Despite a hairy introduction to justice, Wollongong judge made the law his life," in 1972, as a Balmain boy attending that school, Your Honour became one of what is described as the ringleaders in a student strike by a group of boys who refused to cut their trendy long hair. The reporting continues. The school tried to kick out the boys, and when I stepped in to help, the school threatened to expel me, Your Honour is claimed to recall. Back then I was the senior cadet officer. Your Honour will appreciate I'm not actually mimicking your voice, so I didn't have long hair, but for me it was a matter of principle, Your Honour is said to have added. The publication goes on to say that the school didn't succeed because Your Honour's father was a member of the Labor Party who called in Neville Wran QC. Ran's representation worked, and that got me interested in law. The region attributes Your Honour as saying. The anecdote ends with the statement, "Dad, who was a jazz musician and architect, was a bit upset the school tried to expel me, but he was very impressed when I ended up in the Bruce Petty Saturday cartoon in the Australian newspaper, which was probably the best read cartoon in the country back then." So Your Honour was an irresistible teenager. Your Honour went on to graduate from the University of New South Wales in 1980 with degrees in arts and law. 3 decades later, in 2010, UNSW awarded Your Honour its Alumni Award for services to the community. When accepting the award, you were said to have described yourself as having been a libertarian Marxist hedonist in the 1970s, whatever that means. Your Honour also explained how your university years inspired you to be instrumental in the repeal of the Police Offences Act 1901, one of the provisions of which forbade the flying of kites in New South Wales. Your Honour summed up that achievement as being to get Parliament to acknowledge that it's not against the law to have fun. As the Chief Judge has articulated, whilst at University of New South Wales as a student volunteer, Your Honour was one of the cohort who helped establish the Redfern Legal Centre in 1977. In 1982, Your Honour returned to the centre as a solicitor to start a long career dedicated to securing access to justice for all Australians. It is suggested, or it has been suggested, that Your Honour tolerated the relatively low pay because at the time, 3-course meals at the South Sydney Leagues Club cost $1. I understand that in Your Honour's recent 2025 Gold Ring Memorial Lecture at the University of Wollongong, Your Honour recounted 3 anecdotes that remind us how different times were when Your Honour commenced practice. One example Your Honour gave was that the President of the Bar Association was reported at the time as saying, "In the whole of Australia, there are only 1 or 2 legal academics of any value but multitudes who scribble and prattle relentlessly about such non-subjects as criminology, bail, poverty, consumerism, computers and racism. These may be dismissed from calculation. They possess neither practical skills nor legal learning." Your Honour described these comments as a gift that keeps on giving, but they also illuminate some of the norms of the time in which Your Honour commenced practice. In 1984, Your Honour was admitted in the Northern Territory and moved to Alice Springs as an advocate for the Central Australian Aboriginal Legal Service. This involved acting for people in remote communities like Tennant Creek. Your Honour is reported as saying about that time that at night you would lay under your swag under a gum tree to sleep and then turn up to court the next morning, and that it was fantastic. It does sound fantastic. Your Honour then returned to work for the Redfern Legal Service, this time as a principal solicitor. That work has been described as challenging, arduous and rewarding. Your Honour's Redfern colleagues recall your enthusiasm and commitment to the cause of Your Honour's many disadvantaged clients. Those people describe Your Honour as calm, positive, patient and conscientious, with a fine eye for detail and always viewing life through a justice lens. Your Honour is remarked upon for being able to maintain a sense of humour in most situations and for exploiting every known loophole against landlords. When Your Honour was at Redfern, you lived at Wombara near Wollongong, commuting daily on the train. I am told you were sometimes known to camp in the Redfern office if the commute became too much to bear and would keep a swag there for those occasions. Nobody says that you described that swagging setup as fantastic. This sounds a bit mean, but reference has been made to Your Honour's fashion sense at Redfern. Things have been said about a pair of white pants. That situation may have improved when you met your partner, Katrina. We just don't know. In 1987, Your Honour began working for the Legal Aid Commission, appearing in mainly criminal cases. Your Honour first worked in Wollongong in 1989 as a legal aid solicitor, practising in the same court over which Your Honour subsequently presided. In 1990, Your Honour was called to the bar, as we say, and read with Wollongong barrister Stuart Hill, and I'm told informally read with the now Honourable John Baston AOKC. Your Honour initially practised from Lawrence Hargrave Chambers in Wollongong. In 1995, after 5 years at the private bar, Your Honour was appointed a public defender and your practice included the Wollongong region. We here in this courtroom all know that the public defenders are an essential arm of the administration of justice. The role is a difficult one, both in terms of the intellectual and the psychological impost. The cases are often confronting. The public defenders as a group also provide significant educational opportunities to the profession. Your Honour's fellow public defenders recall you as a prodigious worker who was always happy to take on the toughest cases, sometimes at short notice. One such case in the High Court was CTM and the Queen concerning strict liability and carnal knowledge cases. Senior counsel for the applicant was suddenly unavailable and Your Honour stepped in and, as they say, just did it. Other significant cases that Your Honour appeared in as a public defender include the High Court case of Macarian and the Queen, which examined the exercise of the sentencing discretion. As a public defender, Your Honour developed a well-earned reputation for expertise in DNA evidence and became the first port of call for other defence counsel in search of advice on the topic. Your Honour wrote several learned articles on DNA which were published in legal journals. Your Honour also wrote about many other topics. At the time of Your Honour's swearing in 2010, it was estimated that Your Honour had contributed to 24 papers for the Public Defender's Office, and that number has increased. In 1999, Your Honour was appointed Director of the Criminal Law Review Division of the New South Wales Department of Justice and Attorney General, describing your role as a speed bump on the highway to a police state. Once asked to draft a law the New South Wales Government could promote to ward off risks before the Sydney Olympics, Your Honour is said to have responded, "It is already illegal to blow things up." Your Honour took silk in 2004 and was appointed Deputy Senior Public Defender in 2005. After Your Honour was appointed a judge, Your Honour first sat in Sydney and later in Wollongong, where Your Honour managed the list with regular circuits at Bega. The profession saw Your Honour as a highly efficient, fair and respectful list manager. In addition to the list, Your Honour conducted, of course, countless criminal trials and heard many appeals. Those who know say Your Honour had a fine way with juries, telling them that reaching a verdict was a bit like going to Melbourne. It didn't matter whether they travelled by train, plane or automobile as long as they got there. Some of Your Honour's cases were high profile, but whatever the case, as a judge, Your Honour was highly regarded for your capacity to remain courteous and calm to both the profession and litigants under all manner of trying circumstances. In recent times, some of those more difficult, unrepresented litigants have drawn attention from the press. Your Honour is known as being inscrutably fair and an innately kind person. Your Honour is reported as having remarked that the saddest thing in Wollongong over time is seeing grandchildren of your former clients come before Your Honour, and that seeing the third generation of families Your Honour once defended go to jail is very sad. Your Honour has personally observed the pattern where if someone goes to jail, they'll go back to jail, and if somebody's parents have been in jail, then there's a chance their children will follow. One of the reasons Your Honour is held in the highest regard by the profession is your candid and responsible commentary on the administration of justice. Your Honour has weathered some irresponsible press about that. Your Honour is a long-time supporter of the University of Wollongong, having been a mentor to law students and a part-time lecturer there. Your Honour was appointed as an honorary fellow in 1993. The University of Wollongong's annual Goldring Lecture honours the late Professor John Goldring, the university's founding Dean of Law. Each year, a leading speaker is asked to share ideas on important legal and social issues affecting our community. In 2025, Your Honour was invited to deliver the Goldring Lecture. A prominent legal commentator later called your speech a powerful speech for dark times. The theme of that speech was social justice and judging, including Mr Bugmy's case, and our Chief Justice's discussion about judges sticking to the knitting. I repeat part of what Your Honour said on that occasion. This is not from an official record, so forgive any slight misreporting, or at least don't try to sue me. But Your Honour said, judges are obliged to make principled decisions and follow and obey precedent. Judges are obliged to stick to the knitting. If I'm told by the High Court, judges must not take into account the over-incarceration of Indigenous Australians, I must not do so. If I'm told I must impose a mandatory minimum sentence, I must impose that mandatory penalty. It is critically important that law be applied and enforced according to principle. A good judge is not an AI program, facts in, law out, dispute resolved. Judges and judging require discretion and imagination. Your Honour also said, but striving for social justice is critical to being a good lawyer, and you can't be a good judge without being a good lawyer. Social justice principles shape our thinking, inform our values, and influence the way we interpret and apply the law. In short, they matter. Your Honour went on to say, while social justice may play no formal role in my judicial decisions, it has shaped my career as a student at UNSW, a solicitor with Redfern Legal Centre, CAALAS, and Legal Aid Australia, Legal Aid New South Wales, and as a barrister and public defender. I have tried to embed its principles, especially access to justice, into everything I do. Your Honour, they are, with respect, even to a commercial barrister, inspiring words, and your commitment to social justice is well recognised by the bar. Your public service has been invaluable. Your Honour is held in the highest regard by the profession and your peers. I don't presume to speak of your personal life, but we all know that a contribution such as yours to public life owes much to the loving support and sacrifice of family. The bar thanks you and them for your many years of service, both at the bar and on the bench. We hope your commitment has been rewarding, and we wish you all the very best on your retirement. May it please the Court.
Thank you, Ms Whittaker. Ms Jennifer Wall, President of the Law Society of New South Wales.
May it please the Court. I too adopt Your Honour's acknowledgement of country this morning. A fellow judge of this court called Your Honour a thinking judge. This judge elaborated on the notion of thinking judges, one who thinks through the ramifications of their decisions and who considers the forces at work in a person's life which drive them to offend. Speaking in 2015 with the Law Society Journal, Your Honour said, sending people to jail is usually the best indicator that people will re-offend. You noted the irony, as you see it, of imposing long custodial sentences to protect the community, only to have those sentences increase the likelihood that one will re-offend, again harming the community. Indeed, your time on the bench of the District Court, Your Honour, has sentenced offenders whose parents or even grandparents you had previously represented as clients in your time as a public defender. Your Honour was witness to the profound effect lengthy custodial sentences have on these families, often establishing a pattern of children following their parents into jail. Having touched on these intergenerational consequences, I should say that Your Honour knows it's not always so simple. And I would be remiss not to mention that, unlike one Bill Haesler OAM, Your Honour has made no significant contributions to jazz music. Your Honour has been a long-term generous supporter to an important part of Wollongong's community, not just for your work as a judge and as a mentor to law students, but also for your work as a bush carer helping to restore the native environment. Your community is just as equally important to you. But sadly, as with many on the judiciary, Your Honour, who has presided over many hundreds of criminal cases and sentences, has weathered criticism from media of less sterling reputation than the Law Society Journal. In response to the aforementioned interview with the LSJ, the Daily Telegraph published what Justice Stephen Raries called an unwarranted attack calculated to undermine the independence of the judiciary. This was not Your Honour's first brush with the media. A legal aid colleague recalled during your time as a public defender, the two of you being chased by photographers as you left court after having successfully argued to reduce the sentence of Bill Scaife. This hounding by the press takes its toll on one's psyche, especially since Your Honour did not particularly like the photographs of you that were published. But I would remind the court that there are many layers to law and many shades to the legal philosophy that Your Honour believes in, including one which you developed during your time with the Attorney General's Department as head of the Criminal Law Review Division. Your Honour called this philosophy the broccoli principle. Now, any parents who are present might instinctively understand this. No dessert until you have eaten that broccoli. And to the police, no new laws until you prove you are using the ones that were given to you last time. With your encyclopedic knowledge of the law and deep respect for the humanity for all people in your courtroom, Your Honour has been the judge to whom other judges have turned to for guidance. Your Honour is known to be thoughtful, open-minded and eager to listen. The perfect judge, colleagues have said. Your Honour's character reflects consistent attention to social media issues and to justice. And in your judgments, Your Honour often applied the principles of the High Court case Bugmy. This judgment is concerned with how profound childhood deprivation can affect a person's moral culpability. In the case of R versus Ashley Dawn Parsons 2016, where a first offender had wounded her cousin with a knife, Your Honour sentenced Ms. Parson to 3 years imprisonment with a non-parole period of 18 months. You wrote that Ms. Parsons was often exposed to a violent, chaotic and dysfunctional environment. She herself has regularly been a victim of violence. Your Honour considered that these factors worked to reduce Ms. Parsons' moral culpability. Some principles of sentencing, like that of deterrence, could therefore be moderated but not ignored given the seriousness of the crime. Your Honour has always strived to consider the people who appear before you, how their lives have shaped them and how best to enact justice with the tools available. I would like to return to the Law Society Journal. A friend of yours noted that Your Honour's enduring interest in the procurement and the use of DNA evidence in the law, namely in how its reliability may be incorrectly considered above reproach. My team dusted the cobwebs from the archives to find an article Your Honour wrote in 2001, a thorough look at the Crimes Forensic Procedures Act 2000, which introduced guidelines for collecting and using DNA evidence. Your Honour quoted the then New South Wales Police Minister of the day as having said, "The innocent have nothing to fear." As Your Honour wrote subsequently on the topic, no police investigation, expert opinion or scientific process is infallible. Humans are involved. Your Honour leaves a district court that is in many ways quite different to the one that you joined in 2010. The bench's gender parity has improved, as Your Honour has happily noted. The court has become busier, but it is easier for vulnerable people to testify. Technological changes, whilst helpful in some ways, also complicate trials as it becomes necessary to sift through more and more data as evidence. There is also the worry of using analogies which make you seem out of touch. For example, the phrase, "Today's newspaper is tomorrow's fish and chips wrapper." Your Honour worries that the inability to wrap fish and chips in a website could date you. I also note that in your judicial career, Your Honour has only cause to charge a person with contempt of court once, in R versus Kirsten 2024. It came from the concerning rise of a recent phenomenon where the so-called sovereign citizen who had kidnapped her own child chose to represent herself and appeared in court via video link from prison. The sovereign citizen repeatedly insulted Your Honour and others, harassed witnesses, including her children, refused Your Honour's directions and talked over the top of you. That Your Honour has only ever seen such an egregious instance of someone trying to undermine the trial process and a delay hearing the serious allegations with the rise of this collection of ideas is a warning for us all. And that this pushed Your Honour to your only contempt charge is understandable. As President of the Law Society, it's a credit to Your Honour that of the more than 43,000 solicitors in New South Wales that we represent, solicitors only had excellent things to say about Your Honour. You are known for your ability to cut through to the heart of the complex issues, for your succinctness and your persuasiveness. One solicitor told the Law Society that it can be tricky appearing before Your Honour. Judge Haesler reads everything. He always knows what you're going to say. Sometimes he will make submissions that he knows you're going to make. Solicitors will miss Your Honour's presence on this bench, your generosity of spirit and time. Another solicitor told the Law Society that one of her fondest memories of Your Honour was your willingness to give up an entire Saturdays for CPD days to support solicitors. It was, she said, always lovely to see you walking through the door. Your Honour was known to be able to get through huge volumes of work, and as one friend told us, he must be either very efficient or he never sleeps. Everyone seems to agree Your Honour has earned your retirement, even if an upcoming holiday entails Katrina enjoying Tathra Beach while you serve as a judge in Bega. Maybe she will send you a postcard. Your Honour has been talked into a cruise, but of course you intend to maintain your bush care work, and there's been talk of a 6-month sleep. For now, I implore all those here today to keep the noise down following this ceremony so Your Honour may start on that sleep. Your Honour, it has been a privilege to take this opportunity on behalf of the Solicitors of New South Wales to thank Your Honour for your service to the administration of justice these past 15 years on the bench of the District Court and throughout your very long career. As the Court pleases.
Thank you, Ms Ball. Judge Haesler.
With thanks to Joe Self from the Judicial Commission, I want to begin in the Sydney language. Waramai mitiga. Hello, friends. Ningari Nagala Wagnung Maba Gari Gadi Nuadi. We are sitting here on the very beautiful land of the Gadi people. Here in this place 250 years ago, every plant, every creature, every landform had a name. And those names gave those things a place in the law of the land. And that law had for 60,000 years applied the accumulated knowledge and wisdom of the continent's Indigenous people. And I acknowledge the traditional owners of the country on which we meet, and respect must be shown to the custodians of this place. I must also speak to the sad time we live in. I am not at all religious. I am of a materialist persuasion. But I acknowledge today is the 6th day of Hanukkah, but I also acknowledge that Hanukkah is a time of celebration of the overcoming of adversity, a time to celebrate light, not darkness. I understand that following significant trauma, important questions must be asked, but any response must be measured, not symbolic or regressive. Those responses must not undermine the civility and stability that courts bring to our great democracy. And I draw inspiration from a case I wasn't particularly happy with, but what the High Court said in conclusion in the plurality in the case of Munda. Historical functions of the criminal law and our courts include the need to vindicate the dignity of victims of violence, to express the community's disapproval of the offending, to afford such protection as can be afforded by the state to the vulnerable against repetition of the offending, and I stress, to discourage victims, friends, family from resorting to self-help and the consequent escalation of violence between members of our community. Can I therefore urge caution to those, as I've done many times before, when considering new criminal laws, and reference is already made to the broccoli principle, and my comment, the innocent have nothing to fear. If I can add to the second half of Ms Wall's comment, this caution. when someone proposes a draconian law and defends that proposal with the words, "the innocent have nothing to fear," be very, very cautious. As the novelist Terry Pratchett said, that is because the innocent have everything to fear, particularly from the guilty, and from those people who say the innocent have nothing to fear. Can I return to a more light note? Today's theme is to keep you amused at the end of a long career and a very stressful year. I had, when I thought about retiring, thought I would end with the nihilist expression of indifference, après moi le déluge. Unfortunately, the flood preceded my departure. So, devant moi le déluge. How did I go, Flannery? She always corrects my French. I'm more comfortable in Indonesian. Sebelum aku banjir besar means the same thing. But it doesn't have the same history or resonance as the French. Last century, I was asked to contribute to the speeches on the retirement of a not very revered Wollongong magistrate. My remark was not respectful. When a person retires, you should say only good things. You're retiring, that's good. Now, that contribution was rejected with the very succinct statement, it was distinctly unhelpful. For the first but not the last time someone made that remark about a suggestion of mine, thank you, Justice R.A. Hume, who honours me today. Look up his speech on his swearing in as a judge. I will take my own advice. Today, I promise to only say good things. The first good thing, thank you, Chief Judge. Thank you, Deputy Chief Judges who flank me. Thank you to my colleagues who honour me here in the court and online. I'm told there's a champagne breakfast at Parramatta and they're all watching on the big screen, and there are people in regional courts throughout New South Wales. The extraordinary individual and collective wisdom of the judges of this court has to be acknowledged. It has been a privilege to be part of this court. The second thank you, Ms Whittaker and Ms Wall, is for your generous exaggerations. Thank you to your informants for their lies. Each of them will get the bonus they deserve from doctors we trust. Times indeed have changed since I first studied law at UNSW and as a student clerk at Redfern Legal Centre in 1977. There are women on the bench with me, and many more watching online. When I started in law, women on the bench were a rarity. We had Redfern's formidable magistrate, Susan Schreiner, and the trailblazer, Judge Jane Matthews, the first female judge of this court and of many other jurisdictions. In the mid-1980s, the then president of the Law Society, on visiting Redfern Legal Centre, tried his best, and it was always a him with the notable exception of Marla Perlman, to be empathetic. And he blurted out, "It must be so hard working with people who live below the property line." Mention was made of the norms of the time and comment of a gift that keeps on giving, Justice Roddy Marr as he became. He was also reported of saying things about what he called modern judges. And he was trying to be witty, as he often was, but he was trying to be rude as well, as he often was. What he said about modern judges in the mid-80s could, with respect to His Honour, be an ad for the next round of appointments. Modern judges will address any meeting, seminar, Eisteddfod, jamboree, corroboree on land rights, evils of fluoride, the dangers of the new right, the assimilation of ethnics, penal reform, any other subject of uplifting importance. Nowadays, the compassion industry is flourishing and we are all fervently committed. I think he was trying to be satiric, but it could be an ad for a judge in the modern world, and times indeed have changed. I want to thank a number of people, but I'll try and keep it as short as possible. To the court staff, RSB, sheriffs and correctives, you are the engine that keeps this lumbering ship afloat, even when taking on water. I have a tendency to compare registries with the stereotypes of countries. Having practiced for a long time in Wollongong, I can assuredly say it's a bit like Germany, ruthlessly efficient. Bega, it's a bit like New Zealand, kind, slow, 20 years behind the modern world. The Downing Centre, frankly, it's just like Italy. It works, but I have no idea how. Yesterday in Wollongong, I had the opportunity of thanking everyone associated with Wollongong Court and the South Coast legal profession, where I spent most of a significant part of my career as a judge and as a practitioner. I will have singled out a number of people, and Madam Director, thank you for the cakes. Judges can get two swearing outs, but only one morning tea provided by the court. I want to single out my 4 associates, Moira, Jude, Dolores and Shannon, who sits before me, and I do so again. They are well aware of how much I value their support and strenuous efforts to make my judgments intelligible. Shannon will be moving on to work with Judge Abdul Karim, and if Judge Abdul Karim starts prolifically publishing on case law, you will realise it's more my associate who's been responsible rather than me. I want to thank you to the court officers. I have 2 brief anecdotes for those to illustrate the wisdom of court officers. For those of you at the bar who have taken silk, you know that taking your silk vows is very, very important professionally and personally. And you dress up in your silk for the first time in your long wig and you proceed around the courts. When I appeared, I think, in this jurisdiction, there was a court officer taking my name and I did not know the man. He said, "Haesler, that's a familiar name. Are you Bill Haesler's son, the jazz musician?" I said, "Yes." He looked me up and down in all my finery and said, "He must be so disappointed." The second one is something that was said to me on my first day as a judge, and I still pass it on to new judges. The court officer, just as I came on for my first trial, and they ease you in the district court. It was a 4 accused importation, 8 weeks with a view. Now, Judge, when I knock and say, "All stand," you sit. And it's very wise advice. I want to say something about the judges down the food chain. Yours is the hardest judicial job, and it has been my pleasure to mark your work. To those amateurs, no, be nice, Andrew, predators up the food train, I promise to refrain from telling the only known Court of Criminal Appeal joke. Court of Criminal Appeal jokes are like the word mercy, as rare as English words that rhyme with orange. Rather, I will repeat the nicest thing ever said about me by the CCA. In my respectful opinion, the sentencing judgment in the present case followed an impeccably reasoned path to a manifestly inadequate sentence. Justice Lucy McCallum, along with a number of people on the Supreme Court, past and present, was responsible for that remark. She reminded me that she did work experience with me when she was a law student. One way I coped with the workload was to deliver extempore judgments, and I had to trust in RSB and my associates to correct my appalling grammar. I had a wealth of precedents and purple packages to help me give extempore judgments, and most were used and some were shared. Sometimes I used them repeatedly, but I feel obliged to share one because despite my best efforts, no prosecutor ever took a trial decision of mine to the Court of Criminal Appeal using the Section 5F procedure. I can now pass to my colleagues this precedent. Madam Crown, I will adjourn the matter. You have the right to use the 5F procedure, but please don't presume that I give a 5F whether you 5F me or 5Fing not. And as I was never 5F'd and really appealed for legal error as opposed to sentencing leniency, I can truthfully say nice things about the many prosecutors who have endured my lame jokes, interrogations, occasional brusqueness, and lapses into nostalgic reminiscence and anecdote. Thank you all for your patience and persistence. When I was at the University of New South Wales Law School, I only really wanted 2 jobs in the law, to work at Redfern Legal Centre and to be a public defender. Both goals were met. I presumed I would see out my career as a defender, but somewhere, whatever blockage there was evaporated, and I took up this appointment in 2010. For the younger defence lawyers here, I want to repeat a passage from my 2010 swearing in, which is not online, where I speculated based on US research about why people became defence lawyers. Lawyers who have, having been one, having been one, often profane, argumentative, insecure and occasionally eccentric. My conclusions bear repeating. Defence lawyers never plan ahead, ever. They swear, abuse substances and are sexually promiscuous well into their 30s. After that, they mellow somewhat. The profanity never goes away, but oddly, they make loving parents. I was going to close by saying some things about leniency in sentencing. Some of my remarks have already been quoted and I won't repeat them. There are over 13,000 people in jail today. 33% are Indigenous. In 1978, there were 384 Indigenous prisoners in New South Wales jails and about 1,000 prisoners. We thought it was a disgrace then. No one should go to jail unless it is absolutely necessary, and no one should go to jail any longer than they need to go. Occasionally, but rarely, thank you, the new Justice Gleeson on the High Court, judges use the word mercy. Former Chief Judge in Common Law, Justice McClellan, when I asked for a merciful sentence, said, "Mr Haesler, you have other and better grounds." It's not just a French word. I prefer the term reasoned leniency, and my Goldring lecture's been cited. I won't repeat what's said there, people can read it. Very recently, Mr Toomey SC, on the retirement of Justice Harrison, who honours me today, complimented His Honour on the fact that none of His Honour's sentencing decisions had ever been changed on appeal. That comment could never be applied to me, and nor should it have been, with respect to all my colleagues and those who sit in civil. Sentencing is the hardest job we do. If you stick to severe sentences, they are often easier to deliver. The middle ground, similarly. You can get the law right, and if you do, you can avoid the trauma of appellate or worse, media criticism. And opinions about leniency and severity, they differ. Too much caution often means an offender, a person spends longer in custody than their crimes require. And the community have to understand that jails are nasty and brutal places. Here endeth the sermon. Can I conclude by saying how incredibly fortunate I have been for such a loving family? Katrina, Max, my brother Jeff, Roslyn, Dad, Bill Haesler, OAM. He has retired his band, known as the Robbers Dogs, and no CDs will be sold in the foyer afterwards. To my many, many friends who have been with me on this legal career, and Anna Catchman was there in my first year at law school, and I'm honoured that Terry Budden, who taught my first class as a student at law at the University of New South Wales, is here today. I think it was probably Terry's first class teaching that year. Here today, and I look around, and yesterday we had a full house in Wollongong where I've practiced sat for the last 2 years. Friends from my legal career, friends from Redfern Legal Centre are here. I was privileged to sit briefly at the now defunct Hargrave Chambers. There are public defenders. You have made this part of my journey worthwhile. So, what next? I want to sleep at least for a week. I will occasionally help out in country circuits. I'll be going to Bega in June and October, where I have sat since I was appointed, and where, well, in 1990 I captured the criminal list at Bega, and I have a lot of friends and clients, ex-clients and their children and grandchildren of ex-clients down there. My time down the south coast, I have enjoyed floods, fires, shark attacks and other disasters. Next time I'm hoping for a plague of flathead. There's some work I want to do with the Judicial Commission. My friends from the University of New South Wales are here. The presentation of expert evidence in trials, so that that expert evidence is just and fair still needs work, and Una Doyle and I are planning something. Does anyone here have an in with the Commonwealth Attorney General? At CLRD, I renumbered the Criminal Procedure Act. I took the first step in rationalising the New South Wales Crimes Act. I am happy to volunteer, even go to Canberra to revise and renumber the Commonwealth Crimes Act. For those in the know, Section 3ZZWA. Please. I also want to rewrite the New South Wales Crimes Act and make it funny. There are a few good jokes. For those of you who are Monty Python aficionados and can recite every line spoken by the Knights of Ni, watch the video if you don't. Sections 140, 153 and 515 of the Crimes Act all relate to the unlawful taking of shrubberies. The Act needs a lot of work, but I want to remind people of the definition in Section 5 that, to my knowledge, has never appeared in a judgment of the Supreme Court or the Court of Criminal Appeal. The definition of cattle. Cattle includes any horse, mare, gelding, colt, foal, fill, ass, mule, bull, cow, ox, steer, heifer, calf, ram, ewe, sheep, lamb, pig, goat, deer, alpaca, llama, vicuna, camel or dromedary, and, this is the part I like, every hybrid or cross thereof. My brother Jeff, an agronomist from Western New South Wales, that was for you. 10 years ago, I took voluntary exile from the centre of power and moved as a permanent judge to Wollongong. One of my classic friends sent me some Latin, which I do not speak, and spoke of a thing called the fuga, F-U-G-A. Forgive my pronunciation. The fuga involved poets, gypsies, other people who fell out with the powers that be in Rome and didn't want to get executed. The opportunity to leave Rome and go somewhere to the provinces where they could cause as much trouble as they liked, as long as they didn't come back. This is my first time back in big city since I took voluntary exile, and I loved every minute in Wollongong, and I did enjoy sitting here. I was honoured yesterday by a farewell, or what I call a swearing at the Wollongong District Court, in a court where it was the only time I had ever given evidence in that court. Thank you, Terry Budden, for calling me. I was cross-examined by Graham Barr. Not a pleasant experience being examined-in-chief by Terry Budden. That was easy. And started my career in the District Court, primarily appearing there, although I did start appearing in the District Court before Judge Ducker at Court Number 5 at King Street. This brings to an end of an era my service as a judge, although I will occasionally sit as an acting judge. I am honoured by your presence today. I will take a walk now, or as they say in Kamilaroi, Yalu. Thank you all for being here.
Thank you, Judge Haesler. And finally, I invite you all to morning tea in the foyer just outside the courtroom. The court will adjourn.
All stand.